Hey everybody, this is Deb with Truthification Chronicles, and in this video I'm going to take you to the Supreme Court. Yep, that's where we're going. And I wanted to show you their website. They have all different kinds of things on here. If you like, legal stuff, you can even read the transcripts of the arguments. You can listen to the audio. There's calendars, there's filing stuff, opinions. All their opinions are here. You can find the different case documents and just a plethora of things that you can find on this website. So if you are interested in things having to do with legal aspects of what's going on in our country, this is a great resource. It's one of the better sites too when it comes to government stuff. It's very easy to navigate and it works like a dream. I wish they were all this good. But anyway, here's a calendar that shows you what June's like for them. And the blue ones here are non-argument days. The green ones are conference days. And you'll notice there's no red ones, which are the argument days. And that's because they're done with their arguments for now. And down here they have the recent decisions that you can go through, and you can see the opinions of them. You can also see the docket and then the questions that were given to them, the questions presented. So lots of stuff on there. Well, here's their calendar. And the reason that they are done for now with all hearing different court cases is because June is the end of their term, essentially. And they start in October, and you can see they had a lot where they were hearing the cases. And then as it goes on, they have, maybe 6 days a month where they are hearing cases. But then it gets down here to May, and there's no hearing any more cases. So they were finished on April 24th. That was the last day for them to hear any new cases. Everything from this point on is them conferencing and writing up their decisions and everything, because whenever they put out an opinion, it has to have the majority opinion and the minority opinion, and so it all has to be put together. And it can be quite lengthy documents because they want to make sure they substantiate things that they're saying, and especially if it's a minority opinion, they need to give the reasons why they thought the way they did on that particular issue, and why they would have ruled differently if they would have been in the majority. So this is, their calendar. I did want to point out, I know it says they're not in session July, August, and September, but, it's kind of like teachers. People say, well, teachers don't work in the summer. I got news for you. Most teachers actually do work in the summer. They're not necessarily doing the same kind of work, but a lot of times they're going to workshops. They're, going to conferences. Maybe they're even speaking at conferences. And they're learning more information. Some of them are taking classes so that they can improve their instruction ability. So, there's a lot that teachers do in the summer. I mean, sure, they take a lot of time off too to rest, but they also do a lot. And so I tend to think that these people, they're doing stuff during these months right here, July, August, and September. And so I'm sure they're maybe getting more information about their cases that are coming up, because they already know some of the cases they're going to be hearing when this new session starts. So yeah, it's just crazy. And there's so many of them. Well, this came out June 7th. And so I thought I would share a little bit of it with you. It's actually 36 pages long, but it's really spread out, so it doesn't take all that long to read. But a lot of it is dealing with what cases that they've gone over this past year. It's kind of like this year in review. So I do want to point out a little bit in the beginning of it, and supposedly this is by Ruth Bader Ginsburg. That's who it says. Now, whether she actually delivered this as a speech to the Second Circuit Judicial Conference, or if it was just put out as text, I don't know. I don't know of any recording of her. I don't know of any video or anything that has to do with this. But this was what was put out. And they consider this the October 2018 highlights. This is the term that's still going on and is ending at the end of June. Okay, so that's how they count it. It's considered October 2018, even though now we're in 2019. Shortly after our meeting a year ago, Justice Kennedy announced his retirement. It was, I would say, the event of greatest consequence for the current term. Boy, was it, huh? That was great. And perhaps for many terms ahead. Oh, we can only hope so. For the first argument week of the 2019 term, the court sat with only 8 justices. We regained full strength in the term's second week. immediately after Justice Kavanaugh's confirmation. With Justice Kavanaugh's arrival, Justice Gorsuch cheerfully relinquished to our newest colleague the tasks assigned to the junior justice. And I guess I never knew that this is something that the junior justice, the low man on the totem pole, has some responsibilities he has to do more than everybody else. Answering the phone the rare times it rings during conference, opening the door when an aide appears to deliver papers a justice left behind, conveying to the entourage from the clerk's office, the public information office, and other court administrators the dispositions reached at conference, and most thankless of all chores, sitting on the court's cafeteria committee. In other words, I think he's the one that has to order the meals. At least that's what it looks like to me. I don't know. Justice Breyer retained his title this term as the justice who spoke the most words during argument. Oh, man, I spent most of the day today, or at least a couple hours, listening to some of their arguments, oral arguments. And, oh, yes, Breyer, man, he talked so much. He was right in there. But Justice Sotomayor ranked a close second, and boy, did she. And she was kind of rude about things. She did a lot of interrupting. Oh, it was kind of frustrating. But I'm going to share what I found out in that particular oral argument, and I'll give you the links and everything down below, just like usual. But I thought this one was really particularly interesting. Hang on for just a few, and we'll get there. She also asked the first question more often than any other justice, a total of 48 times. I'll believe that, too, man. She was always, right there, the first one to start talking after the person got done presenting their little intro. Justice Thomas, who ordinarily asks no questions because he thinks the rest of us ask too many. I mean, she's got a sense of humor, evidently, or whoever wrote this, or read it, or whatever, broke his silence for the first time since 2016, asking 3 questions in a single argument. Flowers v. Mississippi, a case raising a Batson challenge to a prosecutor's jury selection practices. Okay, don't know what a Batson challenge is. I am not a lawyer, and I do not play a lawyer on YouTube. I just read the stuff, okay? But yeah, so whatever it is, if you know what it is, you can put that down below in the comments, and I'd be happy to find out what it is. Justice Kavanaugh made history by bringing on board an all-female law clerk crew. She just gave him a compliment. Ooh. Thanks to his selections, the court has this term, for the first time ever, more women than men serving as law clerks. Go Kavanaugh. I mean, all these women were complaining that he was so, misogynistic and everything. It's like, hello, he did something that nobody else has done. He brought more women as staff, the law clerks. So anyway, women did not fare nearly as well as advocates. Only about 21% of the attorneys presenting oral argument this term were female. Of the 34 attorneys who appeared more than once, only 6 were women. Some 6,000 petitions for review have been filed so far this term. We heard argument in 70 cases. Now, let that sink in for a minute. There were 6,000 who wanted them to rule on their particular case, but they only heard argument in 70 cases. Isn't that something? What a percentage there. So that means that when something gets to the Supreme Court and they decide to take it up, it's important. And so we should be paying attention to what kinds of things they're ruling on, because these are pretty important cases and they're going to affect a lot of people. I think that's how they actually judge them, that they see what kind of scope it's going to have, and if it can possibly impact a lot of people in the long run. So to that number, add 5 summary per curiam decisions, opinions rendered without full briefing or oral argument. That brings to a total of 75 decisions already rendered, plus those remaining to be released before the court recesses. As of today, we have announced 43 decisions in argued cases. Now, you got that? 75 total, 43, do the math. That leaves a large number, 27, to be announced in the remaining June days. So keep an eye on the SCOTUS page, folks, and in the news, because we're going to start seeing a big bunch of these announced, and some of them are pretty huge. Of the 43 argued cases resolved so far, only 11, or just over 25%, were decided by a vote of 5-4 or 5-3. So That's kind of interesting that only 25% of them were voted like this. The majority of them had bigger margins. So that should tell us something, that some of the things that they're, adjudicating here, it's something that is a constitutional issue that evidently is so obvious that they have to agree on it, and there's not a lot of dissent. Given the number of most watched cases still unannounced, most watched, there's several of those, I cannot predict that the relatively low sharp divisions ratio will hold. So yeah, they still have not, put out all of them, and there's some that are really high profile that we're waiting on. And so she's saying, well, I'm not sure it's going to still be that same ratio. So yeah, we'll see. Of the 70 cases fully briefed and argued, 12 cases, or 17% of our argued cases docket came to us from the Ninth Circuit. Now, that statistic right there, even though it's 17, look past that for a minute, okay, 17% of what they're doing comes from one circuit court, the Ninth Circuit. That should say something, because that means that anything going through that court is more likely to end up in the Supreme Court than any other circuit court in the entire United States. The Sixth Circuit was a distant second place, accounting for 7 argued cases. And remember, this one was 12. It was almost twice as much, the Ninth Circuit. And the overturn rate the Supreme Court has with the Ninth Circuit is like really big. I think it's like 80% or something. So yeah, expect those to be overturned. Of the 5 cases that came to us from the Second Circuit, we have so far released only 1 disposition, so they still have several more. And then she starts going through cases, and there's, several cases, and she talks a little bit about them, but she doesn't tell you how they ruled on them. She just says, well, it's still out there. We haven't ruled yet. And I want to go down here. Yeah. I mean, it's interesting to read, but if you're not into legal stuff, it might not be something you really want. Come on, where's it at? Okay. Because one of the major cases, and this is the one that I spent the time going through, this was a kind of weird one that had to do with a county. It was a charge that a county prosecutor had fabricated evidence in order to gain a conviction of a county board of elections commissioner for forging absentee ballots in a primary election. It was very interesting. It was overturned that the commissioner, I guess, was acquitted, but it was kind of weird. I skimmed that one. It was kind of interesting. I'd like to sit and listen to it, but again, usually the oral arguments are an hour and a half to 2 hours long. So I didn't have time to do that today. But anyway, so let's get past that one because I think it's the next one. Oh, yep, here it is. On the next to last hearing day of the term. Okay, so remember, the last time they heard was April 24th, so this would have been April 23rd in Department of Commerce v. New York. A case of huge importance. Yes, it is. Secretary of Commerce William L. Ross Jr. decided to include a citizenship question on the 2020 census questionnaire. He said he was responding to a Department of Justice request for citizenship data to aid in enforcement of the Voting Rights Act. Okay, that's what he's saying. He did it because we need better citizenship data to aid in the enforcement of the Voting Rights Act. Census Bureau analyses predicted that adding the question would depress the census response rate for non-citizen and Hispanic households, resulting in poorer census data. Evidence from DOJ showed that Ross had sought inclusion of a citizenship question long before the department's request. Well, that's what they're going back and forth on what the evidence actually is. Several states and non-governmental organizations challenged Secretary Ross's decision as arbitrary and capricious and contrary to law in violation of the Administrative Procedure Act. Plaintiffs also asserted that addition of the citizenship question violated the Constitution's enumeration clause. Yep, that's what they whined about. That guy was sent there by Pelosi. So, after trial, in an opinion and order by Judge Furman spanning almost 200 pages in F. Sup. 3rd, the district court ruled for the plaintiffs on their APA claims. The court accordingly enjoined the addition of a citizenship question to the decennial census. So right now it's kind of in limbo. The government pressed upon us the imminent need to print the census forms and asked us to take up the case immediately without awaiting Second Circuit review. We complied with that request. After we agreed to hear the case, 2 other courts, the Northern District of California and the District of Maryland, weighed in, issuing decisions enjoining addition of the citizenship question. Gee, I wonder. Let's see. California and Maryland. I think they are Democrat, aren't they? Yeah. So kind of interesting that's going on here. Speculators about the outcome note that last year in Trump v. Hawaii, the court upheld the so-called travel ban in an opinion granting great deference to the executive. Respondents in the census case have argued that a ruling in Secretary Ross's favor would stretch deference beyond the breaking point. You know, sometimes these Democrats are just drama queens. They really are. Some headline cases from other circuits, then they go on, and, you know, there's so many others that she mentions all of these different things. And then at the very end, she mentions that they've cut down. Let's see if I get down here. Down further. Hang on. It's easier to go up from the bottom. So, on the procedural front, we have followed the lead of the Federal Rules of Appellate Procedure effective July 1st. The word limit for the parties' main briefs has been cut from 15,000 words to 13,000 words. Now, as a writer, I look at that number because when you write a novel, you refer to your novel when you're trying to sell it and everything, and in the whole marketing aspect of it, you refer to the novel by a generalized word count. So I'm looking at that going, oh, that's a few pages. It's 50-some pages, I think. You take whatever number it is and divide it by 250, and you get like the page count if it was a regular novel or, you know, regular book. Usually there's about 250 words on a page. So that's how I figure it whenever I see numbers like that. But yeah, so they cut it down a couple thousand words. But you know what? In going through all this, these people are reading documents that are humongous. I mean, one of them I saw had like 800 and some pages at least because they were referring to page 883. So, wow, there's just so much. Anyway, reply briefs formerly due no fewer than 7 days before argument will now be due no fewer than 10 days. So they're giving themselves a little more time because obviously these guys are inundating them with all of this documentation one way or the other. And, you know, sometimes it's more valid than others. So that's her statement there. I'll leave it down below. You can read the whole thing if you want to. And then I wanted to take you here, which is where the oral arguments page. And you can go through, I mean, look at this. You can go all the way back to 2010 and you can listen to different cases that were argued. You hear, you know, the person who is the prosecution and the defense, and you hear them talk about it and give their statements. And then the judges ask them all kinds of questions. And so all you have to do is go down here. You can click on this and it will bring it up. And so you can see several of them. Yeah. The Department of Commerce v. New York. And that was on April 23rd. And if you look at this, I mean, they still, that day, they did that one, they did this one and this one. So they heard 3 of them on one day, and then they heard 2 on the next day. So yeah, they were busy in April. Wow, they heard several. Anyway, when you click on that, it brings it up where you can get the actual audio of it. You can even download it. And so that's what I have done. And we'll talk about why I'm doing this in a minute. But you can listen to the whole audio. And then I like to bring up the actual text too. Because if you look here, if you click on this, it'll bring up the PDF transcript in another window, another tab or something like that. It depends on how your computer is set up. But anyway, you can go through and then you can follow along what they're saying because it'll like read it to you. So you don't need me to read it. You can listen to it that way. But I can't remember. This was, yeah, see, it was 1 hour and 22 minutes long. So in here, though, we do have, you know, once you have it as the PDF, you can go through and you can check. And Ginsburg spoke, or at least her name was used 15 times. Now, this guy, you know, sometimes when they were talking to them, they would use their name out of respect, and so that could be why some of them are. But yeah, she did talk, and this is about on page 7, so it's not very far in, and so you can hear her actually talk. Now, is it her voice? Well, That's the question, isn't it? Whoever it is, it sounds very lively. I'm not familiar enough with her voice to tell if it's her or not. So what I did was I went to another one, and this one was argued a year ago. This was the Trump v. Hawaii one, where it was the travel ban thing, and they were trying to figure out if, they should let the executive branch actually do that, which was eventually ruled that yes, Trump could do the travel ban. So you can play this and you can hear what she has to say. Again, all you have to do is go here. And she did talk during that one. Now, it has her, in this one, she spoke 5 times. And keep in mind, this was, a year ago. So that was before all this stuff happened to her. So I'm going to play the clip of this right here, this statement, because it's kind of, it's long enough. I think you can get a feel for it. I'm going to play you this one, which is the one that was just done this past April. So a year between them. You tell me, do you think it's the same person or not the same person? Okay, you can tell me that down below. I'd love to see what you think. Sounds the same to me, but I don't know. And maybe you have software that's better than mine. You can go here and get the files for yourself and do your own comparison if you want to. So here we go.
But you mentioned 1182F. And the worrisome thing about this is that the President acts, Congress is the one responsible for making the laws about immigration. It has been suggested in one of the briefs that we read 1182F to allow the President to suspend entry, but only for a period of time long enough for Congress to say yay or nay. Can we just go back a bit to your opening? Why was the citizenship question dropped in 1960 and remained off for all the decades after that? What was the reason for dropping it?
So, what do you think? Yes or no? Same person or not? Well, I thought I'd just put those out there so you could hear them and, see what you think. Because, again, sounds the same to me, but I'm not sure. Anyway, keep your eye on this page right here because these recent decisions, when they start coming out, they're going to be some big time ones. And especially that one about the citizenship question, because you should have heard their arguments. It was really kind of strange because it started out with the guy who was representing the, Commerce Department. And then it went to like 3 people who were representing the other side. So I don't know how it worked that it was like that, but I guess, that's the way it works. But they asked some pretty good questions. Now, the first one that spoke was this General Francisco, and he was representing the Commerce Department. So they asked him all kinds of questions. I mean, they were really kind of brutal with him. So yeah, as they were asking, Sotomayor just kept interrupting, and here she's got a question, and then she goes on and talks for a while, and finally gets to answer, and he gets this much out, and then she interrupts him again, and he tries to explain more, and she interrupts him again, and she was just like really interrupting, and so was Breyer most of the time. They were really getting in there. And when it came then time to have the opposing view, and you had these people who were trying to say, no, you cannot have a citizenship question, then the conservative justices were being pretty nice. And they would, if they started stepping on somebody, they'd step back and say, no, I'm sorry, go ahead. And, they were really nice about it. But I got to tell you, I really was impressed by Gorsuch. Wow. And Kavanaugh did a good job too. But wow, Gorsuch is just really on the ball. And so, Alito and Gorsuch and Kavanaugh were the 3 that really were speaking out for the conservative side. The others were not talking at all. Clarence Thomas doesn't say anything in this. And Kagan had a few things to say, but, that just mostly it was Sotomayor and Breyer on the one side, Gorsuch and Kavanaugh on the other side. But Justice Roberts put in, and Alito put in quite a bit too. So, it was interesting to listen to. I like to listen to it and read at the same time so I can follow along better, because sometimes they really get going on some of this legal stuff and I'm like, I didn't catch that. It just connects better for me. So anyway, I'm going to put all the links to these down below, and essentially just to sum this up for you so you understand what the point was. Of course, Secretary Ross wants to put the citizenship question on the short form of the census. Now, there's a long form and a short form, and then there's this other thing that's called the, AC something, ACS. And that's a survey, American Citizen Survey or something like that. I don't know. They were okay with it being on the ACS. They were okay with it being on the long form. They just weren't okay with it being on the short form because they say that the proof is that when Hispanics see this and non-citizens see it, they will stop filling out the form. Well, that's illegal to do. You have to fill out the form. I mean, it's not a matter of choice. It is something you have to do. And I think it was Gorsuch pointed out that they have not disaggregated the information, the data enough to prove that that was the reason they stopped filling it out. Okay? So, of course, you know, the liberals wanted you to think that that was the reason, but they really have not done enough. So I want to point this out to you. This was their basic question. The liberals were trying to make this their major contention. They said that you're supposed to use this administrative records, and they're supposed to use that to the maximum extent possible. Well, the problem is, on these illegals, there's approximately 35 million people that we do not have administrative records on. And they're trying to say that, oh, yes, you do. You can extrapolate it. They made this model, and you can figure it out from the model. In other words, it's a guess. I mean, we know how well the model worked when it was down to the 2016 election, right? Well, that worked out well, didn't it? The model said Hillary's going to win, you know, and that didn't happen. So models are not necessarily accurate, but they were trying to paint this model as more accurate than actually putting the question on the census, because they said, well, you know, a bunch of people aren't going to fill it out. Well, you know what? If they're not going to fill it out, that's their problem. And the reason they're so panicked, please remember, the reason they're so panicked is the reason they sent this guy, and I think that his last name was Ho, H-O, and Nancy Pelosi sent this guy to make his argument as a friend of the court, the amicus, whatever it is. And he basically presented that, you know, that data is used to determine how many representatives and everything. So that has to do with Congress. So Congress should be in control of all this. And so one of the justices said, well, then why haven't you made a law already about it? I thought that was kind of funny. You know, because really, that's what's going on. It's this whole thing about immigration, too. You know, the liberals sit there and they want to whine about it, but they're not willing to actually take steps and put legislation in place that's going to fix the problem, because they really don't want the problems to be fixed, especially not under Trump's watch. And so this whole thing, this is just so bogus. Their entire argument is like, really, folks? But they kept coming back to this and saying, you need to use that model in the administrative records. That's where you need to get your information. And it's like, but there are no administrative records for these people because they're undocumented and we don't know how many of them there are in the country. That was the whole point of it. And then they were saying that, well, it really has to do with how we proportion our, you know, House of Representatives, and it doesn't have anything really to do with voting rights. It's like, yeah, it really does. So I don't know. The arguments that they had, even though 2/3 of this is their arguments, I thought it was pretty bogus. So anyway, the links will all be down below, and you're welcome to listen to them on your own if you want to. I really did find it an interesting discussion. It was interesting to listen to them. But wow, Sotomayor, I have had my fill of Sotomayor and Breyer right now. I don't care if I hear them for a while. I mean, Ginsburg at least asked a couple of intelligent questions, but these two, wow, they were just going at it. They are so partisan. And that is something that should not exist on our Supreme Court. So I cannot wait until we get Ruth Bader Ginsburg's seat, because we really need that. And, you know, when Trump gets in 2020, can you imagine? I think we're going to have a couple more that he's going to be able to put in, and they're going to last for quite a while. So that's going to be awesome, in my opinion. So that's what I've got for you on this one. I want to thank you for stopping by, and I'll see y'all later.